Legal causation. 1. Legal causation requires that the harm must result from a culpable act, R versus Dalloway, 1847, however, this does not apply where the offense is one of strict liability, R versus Williams, 2011, 2. The defendant's action need not be the sole cause of the resulting harm, but it must be more than minimal, R versus Bench, 1865, 3. There must be no novus actus interveniens. A novus actus interveniens is a new intervening act which breaks the chain of causation. Different tests apply to decide if the chain has been broken depending on the intervening party. A. Act of a third party. The act of a third party will generally break the chain of causation unless the action was foreseeable. R versus Paget, 1983, B. The act of the victim. Where the act is of the victim, the chain of causation will not be broken unless the victim's actions are disproportionate or unreasonable in the circumstances, R versus Roberts, 1971, R versus Williams Davis, 1992, where the victim is an adult of sound mind and makes a decision which causes death, this will break the chain of causation where the decision was free, deliberate and informed, R versus Kennedy, 2007, unless it was within the range of responses which might have been expected from a victim in his position, R versus Wallace, 2018, R versus Wallace, c. Medical intervention, where medical intervention contributes to death, the courts have been inconsistent in their approach. R versus Jordan, 1956, R versus Smith, 1959, R versus Cheshire, 1991.
4. Thin skull rule, eggshell skull rule. Under the thin skull rule, the defendant must take his victim as he finds him. This means if he has a particularly vulnerable victim, he is fully liable for the consequences to them even if an ordinary person would not have suffered such severe consequences. For example, if D commits a minor assault on V who has a heart condition and V suffers a heart attack and dies, D is liable for the death of V even though such an attack would result in no physical harm to someone without a heart condition. This rule applies irrespective of whether the defendant was aware of the condition. R versus Hayward, 1908. The thin skull rule also applies where the victim has refused medical treatment which would have saved them. R versus Holland, 1841. R versus Blowy, 1975.
Law case notes.